Hello, everyone. Welcome to our panel on U.S. law, policy, and practice related to accountability for war crimes. My name is Gabor Rona. Ashika Singh of Debevoise and Plimpton and I co-chair the ABILA IHL committee that is sponsoring this panel. We have four stellar academics and practitioners who each come at this issue from a different perspective. The panel is for CLE credit, and we will give the CLE code later in the event. Each panelist will speak for 10-12 minutes or so, then we'll open it up to questions and comments in the chat and Q&A functions. Our first panelist is Teresa McHenry, the head of the Human Rights and Special Prosecutions section and an acting Deputy Assistant Attorney General for the Criminal Division in the U.S. Department of Justice. Teresa has been a criminal prosecutor for 30 years plus at DOJ, including the Human Rights and Special Prosecutions section, the Domestic Security section, Organized Crime and Racketeering section, and the DC United States Attorney's Office. From 1994 to 98, she was a prosecutor with the United Nations International Criminal Tribunal for the former Yugoslavia, the ICTY. Teresa graduated from Rice University and from Harvard Law School. Ms. McHenry, thank you so much for joining us. The floor is yours.
Thank you, and thank you for inviting me to speak here and with this impressive group of panelists. Strengthening accountability for war crimes as well as for other atrocities and human rights abuses is a goal that the U.S. has valued deeply for decades. U.S. prosecutors were leaders in the Nuremberg trials. More recently, were active supporters of various ad hoc tribunals such as Yugoslavia, Rwanda, Sierra Leone, and Lebanon. Within the U.S. itself, efforts to ensure accountability for war crimes dates back to at least 1979, when the Department of Justice established the Office of Special Investigations, or OSI, whose mission was to identify and expel persons who were part of the Nazi-era persecution. In 2010, OSI and the Domestic Security section, which had responsibility for the criminal statutes, including the War Crime Statute, were merged to create the Human Rights and Special Prosecutions section, more generally known as HRSP. I'll just mention earlier this year, a man who was a guard at a Nazi concentration camp was removed from the US to Germany in what was probably our last World War II case. HRSP is a small section made up of about 25 attorneys, as well as 6 historians who have expertise in various conflicts, as well as language abilities. In addition to our sort of human rights and IHL portfolio, we're also involved in prosecuting international violent crime, and I'll talk about that in a minute because it overlaps, and also on international human smuggling networks, particularly those that impact national security. Of course, in addition to HRSP, United States attorneys' offices throughout the country are engaged in accountability efforts. Notwithstanding these commitments and goals and values, it's no secret that the War Crime Statute has not been used in a federal prosecution to date. And in my brief remarks today, I'm going to touch on 3 points. First, I'll review some of the structural limitations that are part of our U.S. War Crime Statute. Then I'll describe a handful of other criminal statutes that can be used and have been used to prosecute conduct that could be constituting war crimes. And then finally, I'll briefly discuss some of our successes in holding war criminals accountable by using our criminal immigration and naturalization fraud statutes. I'm not going to discuss that, but I, of course, will certainly mention that these investigations occurring years, if not decades before, in war-torn countries and in places where we may have no limited ability to access can be, as a practical matter, extremely challenging. But first, let me start with a review of our War Crime Statute, 18 U.S.C. 2441. First and foremost among its limitations is that it allows prosecutions only where a victim or a perpetrator is a U.S. citizen or a member of the U.S. Armed Forces. This is in contrast to some of our other statutes, such as the torture statute, which allows us to prosecute where the perpetrator is present in the U.S., even if there is no other U.S. nexus. So this limitation means, for example, if we have an official from another country who orders troops to massacre civilians during an armed conflict, we have ironclad evidence of that, and that person was later to come to the U.S., our war crime statute would not allow for persecution because there was not a U.S. National or U.S. Armed Forces as a victim or perpetrator. On a more granular level, in order to bring a successful case, the U.S. War Crime Statute requires us to prove whether the war crime, the conflict at issue, happened in an international armed conflict or a non-international armed conflict. And this is because when our war crime statute was first enacted, it mirrored to some extent, although not completely, existing international laws and treaties which draw distinctions between international armed conflicts, IACs, and non-international armed conflicts, NIACs. Over time, though, as conflicts have changed, the ability to draw a clear line between what's an IAC and a NIAC has been extremely challenging, given the nature of modern warfare, rapidly shifting alliances, proxy wars, and other difficulties in identifying who is part of a conflict at any given time. And in addition, identifying sort of the nature of the conflict and the exact parties and their relationships can be extremely complicated and can have significant foreign policy or national security implications involving classified information. So, but nevertheless, as our statute is currently written, prosecutors have to allege and prove, in addition to the criminal conduct, what type of conflict it is. And it appears as written that this is an element of the offense. So we have to prove the nature of the conflict beyond a reasonable doubt. So in cases where there may be reasonable arguments about the nature of a conflict, we may not be able to charge at all because we cannot charge in the alternative. We have to prove beyond a reasonable doubt. It's also the case that if in fact the conflict is an international armed conflict, then we have to prove under our war crime statute that the victim was a protected person under the definition set out in the Geneva Conventions as interpreted by US law. So proving who is a protected person can be complicated and can turn on technical questions such as the nationality of the victim, whether or not the crime occurred on the home territory of the person who committed a crime. So this means under our war crime statute, if a person murders a civilian taking no active part in the hostilities, that is a war crime. If you murder a civilian in an international armed conflict, however, that may be prosecutable as a war crime only if the victim is a protected person under international law as interpreted by us, and which means that the murder of a civilian in his or her own country during war may not be chargeable. It's also worth mentioning that our statute does not allow us to pursue certain cases and theories of liability that are available to prosecutors in international tribunals and many other countries. In particular, we do not generally have the ability to prosecute on the theory of command responsibility. Now, we may be able to reach certain acts that would be covered under a command responsibility theory through other charges such as conspiracy or aiding and abetting, but the broad command responsibility is generally not available to us. It's also the case that European partners may have war crime statute that cover a broader range of actions. So for instance, there have been a number of countries that have brought war crimes charges where perpetrator photographed himself with a dead body, and the charge is the war crime of desecration of a corpse. A theory that under our war crime statute, I think would be extremely difficult, if not impossible. So moving on to my second point, and on a more positive note, U.S. prosecutors do have other statutes that can be used to apply to hold war criminals accountable. Of course, each of which has their own limitations, but I'll start by discussing the special maritime and territorial jurisdiction laws, generally referred to as SMTJ laws, and the Military Extraterritorial Jurisdiction Act, known as MEJA. So SMTJ allows the U.S. to prosecute certain crimes that occur outside of the U.S. in locations that are controlled by the U.S., such as U.S. military bases overseas. MEJA allows us to bring cases against persons working for DoD or for other U.S. government agencies whose mission relates to supporting the mission of DoD. So both of these statutes could cover acts that could be considered war crimes. And so, for example, in 2007, a former CIA contract employee, David Pissarro, was convicted under SMTJ laws for his actions abusing a detainee in Iraq. And in another case, a former U.S. soldier, Stephen Green, was convicted under MEJA for raping a 14-year-old Iraqi girl and murdering her and her family. And he was convicted and sentenced to multiple life sentences. I'll also mention we have three other statutes that we refer to as the substantive human rights statutes: genocide, use or recruitment of child soldiers, and torture, each of which can be used in the right circumstances to charge individuals for conduct that would constitute war crimes. Of course, again, these statutes have their own limitations, which I won't go into, except to say that none of the statutes have retroactive effect. So they can't be used to prosecute conduct that occurred prior to the enactment of the statute. That means, for example, we cannot use the genocide statute to charge people who participated in the Rwandan genocide, since the Rwandan genocide occurred in 1994, and the relevant portion of our genocide statute that provides for present in jurisdiction was only enacted in 2007. The torture statute, enacted in 1994, does have present in jurisdiction, and that has been the most useful to us. It is a specific intent crime, so we have to prove that the perpetrator specifically intended to inflict severe mental or physical pain of the victim. We are also required to prove that the perpetrator was acting under color of law. These can present some challenges, including where the torture was carried out by irregular forces with limited ties to government actors. But this statute has allowed us to bring cases against perpetrators carrying out horrific abuse during armed conflict. The torture case against Chucky Taylor, who inflicted terrible violence against many victims during the Civil War in Liberia. He was convicted in the US and resulted in a 97-year prison sentence in our first use of the torture statute. DOJ also indicted Suleiman Mujagic for torture he carried out during the conflict in the former Yugoslavia. That case, at the request of Bosnia and Herzegovina, was ultimately dismissed so that he could be extradited to Bosnia to stand trial for both torture and for the murders he committed, and he was convicted then. It's also worth noting that terrorism statutes can reach acts that violate international humanitarian law. The terrorism cases and when that war crimes charges could or should be used is, I think, a discussion for a different day and time. I will note also that the terrorism cases are handled by our National Security Division. So then finally, let me turn to the point, which is our success in using criminal immigration and naturalization laws to hold war criminals accountable. So these aren't easy because it requires us to prove both the underlying crime and to prove that they intentionally lied about that. So it allows a defendant to raise claims such as someone else filled out the form, or there were language issues such that I didn't understand it, or the questions on the US immigration and naturalization forms are confusing. But we have used those statutes to prosecute acts that could be considered war crimes and from involving conduct from countries all over the world, including Bosnia, Rwanda, Liberia, Guatemala, and Ethiopia, just to mention a few. So a few examples, we convicted a man, Mladen Mitrovic, where we obtained a 57-month sentence for his horrific abuse of prisoners at a detention camp in Bosnia in 1992. There's the conviction of Kefelgan Warku for fraud in concealing his abuses in the involving torture and murder in Ethiopia during the Red Terror, and he received a 22-year sentence. There were two different cases involving defendants who were part of a massacre in Guatemala in the 80s. Each of those defendants was convicted and received 10-year sentences. And most recently, the fraud case against Mohammed Jabate for lying about atrocities he committed in Liberia in the 90s, and he received a sentence of 30 years. So in conclusion, despite the fact that we have not used the War Crime Statute, I can say that we are committed to investigating and appropriately prosecuting where we can those who commit war crimes. And thank you, and I look forward to hearing after our other panelists any comments and questions. I'll also say that DOJ and our law enforcement partners at DHS and FBI welcome information about persons who may have committed war crimes and over whom the US would have jurisdiction. We have lots of outreach to NGOs and diaspora communities. And since I'm not sure who's in this audience, if anyone is, given that it's Saturday morning, I just wanted to put a plug in that the justice and our law enforcement partners are always looking for information. So thank you, and turning it back.
Thank you so much, Teresa. That's a great kind of tour of the horizon. And with that introduction, I think it provides a really good segue now into introducing Beth Van Schaack, who will talk more specifically about where there may be gaps and what solutions to those gaps could be presented. Beth is an international law dynamo who is also the Leah Kaplan Visiting Professor in Human Rights at Stanford Law School. She teaches international human rights law, international criminal law, and human trafficking, among other subjects. She has been the acting director of the Human Rights and Conflict Resolution Clinic. Before returning to academia, Beth served as deputy to the ambassador at large for war crimes issues in the Office of Global Criminal Justice at the State Department. That was under Secretaries Clinton and Kerry. And in that capacity, she helped to advise the Secretary of State and the Undersecretary for Civilian Security, Democracy, and Human Rights on the formulation of US policy regarding the prevention of and accountability for mass atrocities such as war crimes, crimes against humanity, and genocide. Beth has a BA from Stanford, a JD from Yale, and her PhD from the University of Leiden School of Law. Her dissertation, entitled Imagining Justice for Syria, has been published by Oxford University Press. And late-breaking news, in case you don't already know, Beth was recently nominated, subject to confirmation by it was nominated by President Biden and subject to confirmation to be the State Department's ambassador at large for international criminal justice issues. Congratulations for that. And Beth, the floor is yours.
Great. Thank you so much, Gabor. And thank you, Teresa, for that terrific introduction to your work and the important cases that you have been able to bring, notwithstanding some limitations within the statutory framework that you have to work with. What I thought I would do this morning is give a little bit of history of the War Crimes Act, which explains how we got to the statute that we now have and are working under, and then discuss 5 amendments and changes to US law and policy that I think would make it easier for the lawyers at HRSP to be able to use this statute effectively when there are individuals who stand accused of committing war crimes within the jurisdictional reach of the United States. As Teresa alluded to, these cases are really hard. Even with a perfect, exquisite statutory framework, there's a lot of technicality to the elements. Amassing sufficient, often battlefield evidence can be really difficult. There's the vagaries of unreliable witnesses. And then there's, of course, the always impenetrable or often impenetrable khaki wall of silence. But because of some of the structural deficiencies in our statute, the United States has made it even harder, I think, to prosecute war crimes than it needs to be. And so I hope in this talk, and there's a paper that's available on SSRN if people are interested in a longer discussion, I hope to outline some areas where I think we could make some, I say quick, we know it's difficult to enact laws, but quick legislative and policy fixes that could make it easier for Teresa and her team to use this statute. So just a bit of history. The United States ratified the Geneva Conventions way back in 1955. And at that time, it was assumed that we actually didn't need to enact implementing legislation because we could use existing law to carry out any prosecutorial obligations set forth in those treaties. We were thinking at the time about state federal law and also the newly enacted Uniform Code of Military Justice, which we're going to hear about at length later in this panel. The theory was that these took care of our treaty obligations. Then there was some Supreme Court precedent, et cetera, that suggested some limitations to the Uniform Code of Military Justice and that the obligations contained within the Geneva Conventions and what that code allowed were not coextensive. And there was some recognition that we needed additional authorities. And interestingly, it was the conflict in Vietnam that really inspired Congress to take another look at this question, because they realized that war crimes committed against US service members were not necessarily easily prosecuted under extant US law. And so that was really the inspiration for revisiting what the Geneva Conventions require and what our law enables. So there were a number of hearings held and various versions of the statute ultimately considered and then enacted. First and foremost is this question of personal jurisdiction. The treaties make pretty clear that all high contracting parties should be able to prosecute grave breaches of the treaty when committed during an international armed conflict, notwithstanding the nationality of the perpetrator or victim or the place of commission. There were some proposals to that effect within US law. Those were ultimately not enacted. Ironically, or maybe paradoxically, given Teresa's remarks, it was the DOJ that was somewhat resistant to having full kind of what we would think of now as universal jurisdiction over war crimes. The Department of Defense and the Department of State both had high-level officials testifying before Congress in favor of having more expansive present-in jurisdiction. In part from the perspective of being true to our treaty obligations under the treaties, but the State Department also indicated that this was an important diplomatic tool, that if we expected other states to fully ratify and incorporate those treaties, we should also be doing so within our own domestic code. Nonetheless, where we landed was, as Teresa described, a statute that allows for jurisdiction only if either the perpetrator or the victim is a US person or a member of the armed forces. There were also some initial limitations on the substantive war crimes that could be prosecuted, starting with the grave breaches regime, but eventually different iterations of bills and ultimately the War Crimes Act as enacted now allows for jurisdiction over grave breaches of the Geneva Conventions, which can only be committed within an international armed conflict, some breaches of the regulations attached to the old Hague Convention of 1907, some weapons crimes that are subject of a discrete treaty, and then as originally drafted, breaches of Common Article 3. Now this was interesting because Common Article 3, as you may know, doesn't contain a penal regime. It just has a list of offenses. States are obliged to repress those offenses, particularly when committed by their own personnel, but they're not required to necessarily criminalize them. So our original War Crimes Act actually went beyond what the treaties provided by criminalizing those violations of Common Article 3. This was where the statute remained for some time until the revelations of the abuse at Abu Ghraib emerged. And at that time, Congress revisited the War Crimes Act through the vehicle of the Military Commission Act and decriminalized two violations of Common Article 3. First, the violations of the dignity of individuals, and second was the due process violations, prosecuting someone under a system that doesn't adhere to full due process protections. Both of those original listed violations or offenses under Common Article 3 were decriminalized. And then finally, just jumping quickly forward, in 2008, we enacted a child soldiers statute. This one also has not yet been used, although it's been effective in certain respects in keeping individuals out of the United States that had engaged in the use or recruitment of child soldiers. This also allows for the prosecution of any individual present in the United States. So it has that broader jurisdictional reach. So my first fix would be, of course, to revisit this personal jurisdiction question and to render the War Crimes Act consistent with our other international crimes legislation. And that would allow for the prosecution of any individual found present in the United States or found in the United States. Those are the two formulations that we see in these other international crimes statutes. The second limitation that Teresa mentioned is this question of conflict classification. And this too, I think, could be a relatively easy fix. It's very much a question of path dependency because the original treaties are very much dependent upon this idea of conflict classification. But if you look at the jurisprudence emerging from the ad hoc war crimes tribunals and now Article 8 within the Rome Statute, we see that the war crimes that may be prosecutable under these two bodies of law are really converging into a consistent corpus of war crimes. And the magisterial customary international law study of the International Committee of the Red Cross makes clear that most war crimes now may be prosecuted regardless of the nature of the conflict in which they're committed. And so if we could simply abandon those conflict classification references, for example, even to the notion of a grave breach, which we know is tied back to the Geneva Conventions, or references to Common Article 3, which we know applies only in non-international armed conflict. If we just simply listed the prosecutable acts without reference to these treaty buzzwords, then it would be much easier for Teresa's team to be able to prosecute and would not have to prove the nature of the conflict as an element of the offense. She mentioned the problems here, but you can imagine a situation in which there is some dissension, even within the US government perhaps, or within the multilateral world as to how to characterize a conflict. Is Russia sufficiently controlling militia and non-state actors in Ukraine in order to internationalize that conflict? That's an extremely complicated consideration that will have foreign policy, national security implications, and may depend upon classified information that the government would not want to be revealed within the context of an open federal prosecution. And so it's quite a complicated factor of this statute and could be easily obviated by simply listing prosecutable acts without reference to the nature of the conflict. And because customary international law now accepts that, there are no ex post facto or nullum crimen problems. Teresa also mentioned the concern about protected persons. This relates back not only to the terms of the treaties themselves, but to two interpretive memoranda that emerged from the Office of Legal Counsel within the Department of Justice. As we know, there were a number of interpretive memoranda that were released during the so-called War on Terror. Many of those memoranda have been withdrawn and repudiated by either the Bush or the Obama administrations, but there are two that quite curiously remain on the books. And the nature of the reasoning is just so convoluted that I simply cannot get into it here, and it's extremely hard to summarize, but suffice it to say that both memoranda assume that a protected person is only someone who is either in the hands of the party to which they're not national on that party's territory. So in other words, individuals in US custody here in the United States, or within a situation of occupation. So individuals who are in the custody of a high contracting party, not within a situation of occupation, but also extraterritorially, do not constitute protected persons pursuant to these two interpretive memoranda that probably are, I don't know the status fully of those under US law, but they probably are considered definitive and so would guide the interpretation of our statute. So repudiating those statutes from the executive branch and then perhaps even articulating, if Congress were to revisit the War Crimes Act, some sort of sense of Congress to explain the fact that protected persons also include anyone who is not protected by one of the other three Geneva Conventions, 1, 2, or 3, dealing with the wounded and the sick and the shipwrecked and POWs, but are either civilians or someone who falls outside of one of those other three, still are entitled to protection and are considered protected persons, even if it's not a situation of occupation and even if they're held extraterritorially vis-a-vis the high contracting party. That was a little confusing. I'm happy to entertain questions about it, but I can say that the reasoning in the memo is quite convoluted, even though they keep saying it's the clearest reading of the treaties, which is difficult to swear. Teresa mentioned superior responsibility. That is a very clear gap in our law. It could easily be included within some sort of omnibus technical clarification act that would fix some of these other problems within the War Crimes Act, or there's been a lot of interest and energy around enacting a Crimes Against Humanity statute, which is not the subject of this panel, but it's been brought up in earlier panels, but it's also a glaring gap within our federal penal code. And so I could imagine adding a superior responsibility provision into a Crimes Against Humanity Act that would then apply more broadly across all of the elements of Title 18 that address international crimes. And we could also do this fix within the Uniform Code of Military Justice. There's actually a very good articulation of the doctrine of superior responsibility in the Military Commission Act. So a simple fix would be to simply refer to that by reference and have it apply more broadly within Title 18. And finally, I would suggest, and Teresa also alluded to this, recriminalizing those elements of Common Article 3 that were decriminalized within the Military Commission Act, and most importantly would be this outrages upon personal dignity, including degrading and humiliating treatment. As Teresa mentioned, there have been a number of successful war crimes prosecutions in Europe emerging out of the interconnected wars in Syria and Iraq, because individual fighters have posted on their social media platforms trophy videos of themselves desecrating a corpse. It's very often been very difficult to prove that those individuals were involved in the murder of those victims, but it's sort of a res ipsa loquitur of, if you're holding a severed head, you've desecrated a corpse. Those courts have determined that a dead protected person is still a protected person, and so they've been able to use the crime of outrages upon personal dignity in order to prosecute those individuals. So in closing, I'll just note that all of these structural deficiencies, et cetera, can be addressed through very discrete legislative fixes, new legal interpretations, and policy pronouncements. And this would really help actuate this woefully underutilized prosecutorial authority that Congress has itself enacted and clearly wants the United States to be able to prosecute these crimes. It would allow us as a nation, as a high contracting party, to live up to our state responsibility obligations to ensure accountability for breaches of IHL. It would strengthen this prosecutorial tool for Teresa and her team, and also strengthen the ability of the United States to mount credible complementarity arguments, because we have a stronger domestic framework to prosecute international crimes. So I'll rest there, and I really look forward to the discussion.
Thank you so much, Beth. May all those reforms come true. Our next panelist is Rachel E. Van Landingham, retired Lieutenant Colonel. Rachel is a national security law expert and a former judge advocate in the U.S. Air Force. She's an associate professor of law at Southwestern Law School. During her military career, Rachel served as a senior legal advisor on the international law of armed conflict, as military prosecutor, as a criminal defense attorney, as an appellate defense attorney, and as a nuclear surety inspector stationed in the United States, in South Korea, and in Italy, with deployments to the Middle East. She was the legal advisor for the international law headquarters of U.S. Central Command, and also served as the command's chief liaison to my former employer, the International Committee of the Red Cross. Rachel, I'm going to give you the floor, and I'm also going to make sure that you have the capacity to share your screen. There you go.
Terrific, wonderful. Thank you, Gabor. And it's my honor to join everyone here today. And since I'm terrified to follow a future ambassador in my remarks, I'm resorting to PowerPoint so that I don't completely fail. I did make full professor a couple of years ago. Maybe I've been demoted, but I should update my own bio on that. So I'm very proud of that. It's a very small accomplishment. So I would like to pull us back a little bit to why accountability is important. And we've heard wonderful discussions regarding accountability through federal criminal law, and then the problems with the War Crimes Act and why it has not been utilized. The number one tool used for accountability for war crimes has been the military justice system. And the military justice system has some structural defects that my colleague, Professor Korn, and I have written about and proposed remedies for. So our remedies are with the goal of strengthening American war crimes accountability and accountability for those who most often perpetrate these crimes, which are soldiers, sailors, Marines, airwomen, airmen, and Coast Guardsmen, those in uniform. So I'd like to take a step back, and I'll be covering three things. Why accountability, and accountability for what? What's the point? How does the military justice system currently provide a set accountability or try to provide a set accountability? What are the structural defects with that system, and what are our proposed remedies? But I can't do any of that without pointing out the elephant in the room. So the elephant in the room is the perceived lack of accountability for war crimes committed by U.S. service members. And this lack of this perception goes back decades, but it was on steroids. It received a steroid shot by former President Trump's pardons of numerous convicted war criminals that were convicted within the U.S. military justice system or that were facing investigation and courts martial for their alleged crimes. So taking a step back, what accountability are we talking about here? We're talking about accountability for serious violations of the laws and customs of war, the law of armed conflict, international humanitarian law. Why is accountability needed? Why is criminal punitive accountability needed? It sounds really basic, but I sometimes find that with my students, the basic things are the most important. IHL, LOAC, is based on the premise that law that isn't enforced is not effective. Law that is not enforced is simply not effective. The LOAC, the law of armed conflict's goal of reducing suffering in war, cannot be achieved unless its rules are enforced, and enforcement depends on effective accountability. It's really that simple. Professor Korn and I rest our paper on it and supplement this idea, this premise that accountability absolutely demands compliance demands enforcement on the legal duty of soldiers to follow the law of armed conflict, the pragmatic necessity and the legitimacy, the pragmatic necessity regarding the acknowledgement of gains on the battlefield, the acknowledgement of winning in war depends on, and it's directly linked to compliance with the law of armed conflict and legitimacy effect that Jeff is going to go into in much greater detail, and the moral imperative of following the law of armed conflict. The idea that the moral integrity, the moral compass of service members depends on the adherence by their unit and by themselves to this corpus of law. One of the Geneva Convention's greatest contributions to the LOAC field was its enforcement trifecta, dealing with such accountability, as we've heard in terrific detail today regarding grave breaches, the obligation to enact domestic criminal legislation to prosecute such breaches, which, as Beth mentioned, was originally deemed not necessary because the UCMJ, the Uniform Code of Military Justice, it was considered to have handled it. And several of our partner nations followed that route as well. They thought, okay, all the war crimes, that's okay, it's already covered. Prosecution will be covered within the UCMJ until 1996. As well as the search and prosecute duty. So if the military justice system has been the preeminent system to provide accountability for serious violations of the law of armed conflict, how does it do so? The military justice system today, as it has been going back to 1775, is a commander operated and owned system that was inherited from King George III through the Articles of War that actually predate the Constitution. Today, unlike many military justice systems around the globe today and most of our allies, the United States maintains prosecutorial discretion within non-lawyer commanders. And that's that's tied up right now within a huge push for military justice reform to take prosecutorial discretion from military commanders, non-lawyer commanders, and vested in independent military lawyers that are independent from the chain of command, that are experienced military prosecutors. But the military justice system, with the general court-martial at its heart, is one through which service member accountability is ensured, and it contributes to good order and discipline and unit effectiveness, the pragmatic purposes of military justice that everyone from David Kennedy to George Washington has acknowledged. What are some of the actual weaknesses here? The weaknesses of the Uniform Code of Military Justice that Jeff and I weren't the first to highlight, but we're the first to really contextualize within the responsible command obligation of the law of armed conflict. The primary weakness is the lack of enumerated war crimes offenses. Even though the Uniform Code of Military Justice today, through Articles 18 and 21, allow for the military to prosecute war crimes, serious violations of the law of armed conflict. It has always been the policy of the Department of Defense to not prosecute war crimes as war crimes. Instead, these crimes are prosecuted as common law crimes. They're a murder that occurs, such as an alleged murder by Navy SEAL Gallagher on the battlefield of Iraq, is charged as a common law murder. It is not charged as a war crime. And this goes back decades, and it really dovetails with the simplicity, the prosecutorial simplicity that Teresa mentioned earlier of why have to go through the bases of proving that there's actually the characterization of an international armed conflict, non-international armed conflict, et cetera, when you can just focus on the actual gravamen of the crime. That is, you can focus on just prove murder instead of having to prove that the murder occurred on the battlefield. But Jeff and I argue very forcefully in our article that degrades the effectiveness of the law itself and contributes to a perception that there is impunity for war crimes of U.S. soldiers. Because even though Sergeant Bales was convicted of multiple counts of murder for his war crimes that occurred in Afghanistan, he was not convicted of war crimes. He was convicted of murder. And why not? Because because the Department of Defense's policy is to not charge war crimes as war crimes, primarily because of pure simplicity. But that degrades the effectiveness. It ignores the societal harm to the military as well as to the United States society writ large that the label of war crimes actually bring with them. So Jeff and I recommend that not only should enumerated war crimes be included within the Uniform Code of Military Justice, and there's a really easy way to do it, and that's not to look to the ICC's list, but it's to look to the list that Congress was already able to enact, and those are the enumerated war crimes offenses that are already found in the Military Commissions Act of 2006 and 2009, minus a few that seem a bit that not only seem a bit suspect, but have been found already to not be war crimes, such as conspiracy to commit a war crime. We also identify within our article that there is, and this was mentioned earlier by Beth and Teresa, the military justice, the Uniform Code of Military Justice does not include commander responsibility, indirect liability for the crimes committed by subordinates. Instead, what the Uniform Code of Military Justice provides is pure aiding and abetting and standard accomplice liability. Under the law of armed conflict and under the famous U.S. Supreme Court Yamashita case, command responsibility would allow a commander to be charged for the acts of his or her subordinates and be criminally liable for them if they knew or should have known of those war crimes, if they failed in their duties of responsible command. The duties of responsible command being to prevent, suppress, and punish violations of the law of armed conflict. And so while currently under the UCMJ, commanders can be held responsible for failing in their command responsibility duties through a dereliction of duty charge, which is a much less serious, obviously much less serious crime. Really, it's a maximum of up to 2 years of jail time. but that's much less serious than actually being held liable for the war crimes a subordinate commits. So within the UCMJ does not provide a command responsibility theory of liability. It was tried under the Medina case flowing from the My Lai massacre, and it was shot down there and has not been used since. And so Jeff and I recommend that command responsibility theory of liability be enacted within the UCMJ. And indeed, Congress is able to do so because it does provide for superior responsibility for alien unlawful belligerents. And so this really highlights that there's a huge gap between how we treat our enemies under the law of armed conflict and how we treat our own soldiers, and that greatly contributes to the perception of impunity. And there is also a component of the commentary to the First Geneva Convention prohibits having special tribunals and special procedures just for enemy combatants versus how we deal with our own. There's a huge normative issue there. As I mentioned, just to highlight how alleged war crimes are actually charged under the Uniform Code of Military Justice. They are charged as common law crimes. They're not charged as war crimes. And I misspelled pardon here, but we have a seemingly tradition now of pardoning those that are convicted of war crimes. And I'd like to mention the individuals that were charged for the Blackwater war crimes under the Military Extraterritorial Jurisdictional Act. They were also charged for common law crimes instead of being charged for war crimes. They were also pardoned by President Trump. But there is a fix. There are enumerated war crimes that Congress has already been able to pass and to enact, and those are under the Military Commissions Act. What's good for the goose is good for the gander. Those should be incorporated within the Uniform Code of Military Justice, and the same standards applied to our own service members as we're willing to apply to our enemies. That will cause Congress to hopefully rethink things such as material support to terrorism and aiding and abetting a war crime, as whether or not those truly do constitute war crimes. And so here are some of our recommendations. I'm going to leave it to Jeff to provide the greater focus on why do we really need this? What is this so-called accountability gap that we identify in our paper? It's linked to legitimacy and it's linked to effectiveness on the battlefield. So thank you so much.
Thank you, Rachel, and my apologies for demoting you to associate professor. But that was a great snapshot into the UCMJ issues. As Rachel mentioned, our final speaker is my sometime sparring partner, Jeffrey Korn. Jeff is the Gary Cooper Distinguished Professor of National Security Law at South Texas College of Law in Houston. Jeff is a retired U.S. Army Lieutenant Colonel, where he served as both an intelligence officer and a JAG officer. His career culminated as the Army's senior expert advisor on the law of war. Let me add a personal note. I know of no one who has done more than Jeff to bridge military and civilian understandings of the law of armed conflict. With that, Jeff, you have the floor.
Okay, I'm done. I mean, that's the nicest thing anybody's ever said, from the ageless Gabor Rona, who fails to mention that our first element of sparring occurred, I think, in a bathroom at some conference where he approached me and said, "Do you really believe what you're saying up there?" or something, words to that effect. But it is a distinct honor to be here. And Gabor, I'm very grateful that both for our friendship, the way you've pushed me to think about things, and also for the opportunity to be here. So I want to pick up from where my friend Rachel left off. The genesis of this piece for me was a simple question. Why have we enumerated war crimes for our enemy, but we continue to persist in this kind of what I think foolish modality of refusing to charge war crimes when our own subordinates do something that the external community believes should be treated that way? Why don't we give commanders, and it really doesn't matter to me whether it's a commander making the prosecutorial decision with the advice of the JAG, or if it's ultimately reversed pursuant to current efforts to change the military law, that it's a JAG officer exercising prosecutorial discretion with the advice of the commander. Why don't we expand the prosecutorial options for battlefield misconduct? There will be situations, as Teresa says, where you can have a complex operational situation where you're not sure whether the law of war or the law of armed conflict has been made applicable, for example, a peacekeeping operation in Bosnia or Haiti or Somalia. And in those situations, having the ability to revert to the common law crimes makes good sense. But in other situations, it's relatively apparent, and certainly apparent enough where Congress has said for our enemies, we can charge you with war crimes. And by the way, the idea that Rachel mentioned, I don't think we can overemphasize. We are not suggesting a whole cloth importation of the Military Commission Act enumerated offenses into the UCMJ. In fact, one of our arguments is that by looking to the MCA to decide what offenses should be incorporated into the Uniform Code of Military Justice, it might create more reticence on the part of Congress to say this is or is not a war crime, which should then lead us to reconsider why we put it in the MCA, for example, hijacking or material support to terrorism. So we think there's a lot of value in doing that. What I want to focus on is kind of the big picture. Why does this matter? And it comes down to one critical word, and that's legitimacy. When we talk about legitimacy as a strategic and operational enhancing element, most people would be surprised to learn that in a recent change to joint military doctrine, the capstone doctrine for the US military, Joint Publication 3-0, lists what are called principles of joint operations. These are principles that are derived from traditional principles of war that go back to Jomini and Napoleon and Clausewitz and et cetera. So you wouldn't be surprised to see principles like objective, offensive, mass, maneuver, economy of force, unity of command, surprise, simplicity. But what the Department of Defense has done recently is it's added three: restraint, perseverance, and legitimacy. And let me read to you what it says about legitimacy. The purpose of legitimacy is to maintain legal and moral authority in the conduct of operations. Legitimacy, which can be a decisive factor in operations, is based on actual and perceived legality, morality, and rightness of actions from the various perspectives of interested audiences that include our national leadership and domestic population, governments, and civilian populations in the operational area, and nations and organizations around the world. This is the reality of contemporary military operations. What one Marine general about 2 decades ago called the problem of the strategic corporal. A corporal on a checkpoint in Syria or Iraq or Afghanistan can make a decision this morning that has strategic consequences tonight when it's broadcast on CNN. And part of that legitimacy is signaling to the rest of the world that when our subordinates cross the line from legitimate and lawful military conduct to illegal conduct, when there's credible evidence that that occurs, that our commanders and our military lawyers are not only capable, but are ready to hold them accountable for those errors. And as Rachel says, if all we're doing is prosecuting for aggravated battery or aggravated assault or mistreatment of a prisoner, it sends a potentially erroneous message that the US military doesn't take this stuff seriously. And if anything, it's the exact opposite. Teresa mentioned the former soldier that was prosecuted in the Western District of Kentucky under the Military Extraterritorial Jurisdiction Act for raping and murdering an 14-year-old Iraqi girl. The rest of that group of miscreants who committed those crimes were prosecuted by general court-martial at Fort Campbell, Kentucky, for murder and rape and conspiracy to do the same because they hadn't left the military. And yet the case that gets attention is the one that's in the federal civilian court, and we tend to overlook the effort to prosecute and establish accountability in the military courts. So there are a couple of reasons why I think, and Rachel thinks it's very important that we expand this scope of prosecutorial options. The nature of conflict is changing. I'll read another headline that was from Defense News yesterday, or Military Times yesterday. Army expects fierce, close combat in next war despite advanced tech. The military today is not expecting an endless era of counterinsurgency where you have information dominance, combat dominance, and the ability to integrate legal advisors in the most complex decisions. What the military is preparing for is a resurrection of what I grew up with when I started as an intelligence officer in 1984, which is combined arms maneuver operations conducted under dispersed theories of what's called battle command, where a commander gives a broad intent and relies on subordinate commanders to execute that intent in accordance with the goals of the mission. That means that the decisive issues related to compliance with law during these operations is going to be made by junior level leaders who rarely have the luxury of being able to reach back to legal advisors to get timely and immediate legal advice. They need to be prepared for this, but they also need to know that there are lines that cannot be crossed because they are going to become the decisive element of legitimacy. And if we fail to give commanders the ability to establish meaningful accountability in a way that is recognized by the external audience as legitimate, then we're undermining the strategic objective of those immense sacrifices that those men and women are making. I think there's another important second order factor here that is not often considered, and that is if we empower military courts martials to adjudicate war crimes, particularly in the context of the conduct of hostilities, it's going to contribute to a body of jurisprudence that's going to help clarify how these principles are in fact implemented in war. For example, the complexity of a battlefield attack decision is subject to a legal constraint. You have to make an objectively reasonable judgment that what you're attacking is an enemy objective, that you're using a method or means of warfare that is not indiscriminate, that you've implemented all feasible precautions. We can all talk about those rules, but when we translate those rules to criminal accountability, it's a complex process, and there is not that much jurisprudence out there that helps us identify the point where a commander's decision shifts from a reasonable mistake to an unreasonable decision justifying criminal accountability. And I think military courts are in a good position to help clarify that understanding. I think using military juries who've experienced the fog of war and the trauma of combat would actually lead to results that might surprise people. I think that a military court would be more inclined to be demanding on a commander who's being subjected to accountability for an erroneous decision in combat. But I also think it would play another important point, and that is to push back against what I've called the corrosive effect of effects-based condemnation, where if we're not doing cases where there is credible information that an attack decision was flawed sufficiently enough that it justifies criminal accountability, then what we're doing is we are feeding into the system where all judgments of legitimacy and legality are driven by the effects of combat. And that's a distortion. Effects of combat are unquestionably probative of compliance or non-compliance with the law, but they're equally unquestionably not dispositive. If all we do is look at the effects of an attack and extrapolate from those effects that there must have been a war crime, then what we're really doing is we're saying 1 + I don't know = 5. The I don't know is the why did you attack? What were you attacking? How did you attack? Why did you make these decisions? And criminal trials, the adversary process of a criminal trial will force exposure of that process. And I think that would have an effective impact on broader international criminal jurisprudence in tribunals where you don't necessarily have the benefit of extensive military experience. One other point I wanted to make is that in the article, it's a big article and it covers a lot of different points. Rachel put the point up there about making sure enemy belligerents are subject to military courts. There's a really perplexing and bizarre amendment to the Uniform Code of Military Justice that says a court-martial only has jurisdiction over a privileged belligerent. I can't figure out where it came from. I asked the Judge Advocate General, When I asked him, he was as surprised by it as I was. I think that it was an effort by someone in Congress to close the option of using a court-martial for enemy belligerents in Guantanamo by saying they're not subject to military law. But it's absurd because we're not charging them with violations of military law. So what it's really done is it's created this weird situation where if a detainee in Guantanamo attacks and kills a US military guard, there's no jurisdiction over that individual anywhere. Yeah, unless you're going to turn him over to Cuba and have Cuba prosecute him. He's not subject to federal law. He's not subject to the UCMJ according to this odd amendment. So we think somebody needs to look at the folly of that. The other point that I brought up in the opinion has to do with the Goldstein case. You all may remember Major Goldstein was the Special Forces officer who allegedly laid an ambush to kill a detainee in Afghanistan that he had been ordered to release. And he admitted it during a polygraph to get a job with the CIA, and it was turned over to the military, and he was charged with premeditated murder under the UCMJ. And as Rachel says, President Trump preemptively pardoned him. So that case never went to trial. But one of the things that I started to think about, which I think is really, I'm not sure if I'm right on it, but I think it's pretty interesting. If you have a situation where there is, you accept the fact that the person that the soldier is killing is an enemy belligerent, but the rules of engagement prohibit the use of force in that situation, is that an unlawful killing, or is that just a violation of an order? It's unquestionably a violation of an order because you violate the rules of engagement. Had I been Goldstein's defense lawyer, I would have asked the court to instruct the military jury that if a soldier kills an enemy belligerent who is not hors de combat, under international law, that is a lawful killing. And if you charge a soldier with murder under the UCMJ, you must prove beyond a reasonable doubt that the killing was unlawful. So my argument to that jury would have been, go ahead and convict him for willful disobedience of an order because he violated the ROE, but he didn't commit an unlawful killing. Now, the reason I say I'm not sure on this is because some of you may know my brother Gary, who pushes back on this and says, your privilege to engage in violence and war is a privilege derived from the state. So if the state restricts it, then violating that restriction makes the killing unlawful. But we think an important and easy solution here is to incorporate into the punitive articles of the UCMJ an aggravated form of willful disobedience of an order. When a subordinate willfully disobeys rules of engagement, and that willful disobedience has the effect of a killing or a serious injury, then the permissible penalty should be aligned with the underlying offense. So the aggravated form would say, if you kill somebody in a violation of the rules of engagement intentionally, then you could be subject to the same penalty that you'd be subject to for murder. And I think that would also help in situations like peacekeeping operations and low-level conflict operations, where it's not clear whether the killing was legally justified from an international law standpoint, but it is abundantly clear that it was a violation of the commander's restraining orders. Thank you.
Thanks very much, Jeff. We're now going to give everybody the CLE code, which is 937472. And I will also put it in the chat in a moment. And then we'll go to some Q&A. So please formulate your questions. We have a little bit less than 10 minutes to go. One question comes from Peter Margulies, hi Peter, who asks, what about drones? Do they constitute an accountability gap potential? Anybody like to take that up?
I'll take it up, considering I have a close relative who's behind the controls of one of those things. Oh, autonomous drones. Oh, okay. I just saw the curveball coming at home plate. Hi, Peter. Listen, I think the issue of autonomy, I wrote about this about 10 years ago. I think the issue of autonomy is creating great stress on the notion of command responsibility. In my view, the entire notion of command responsibility is that the soldier, when he's given to the commander, is an unfinished product. And the commander, through the exercise of command responsibility, is finishing that product, is developing a sense of how you navigate the very difficult line between violence and war and respect for law. But when you field an autonomous weapon to a commander, the commander has no ability to influence the judgment of that, that artificial intelligence. So I think, Peter, what it demands is that we start to think about a modification of command responsibility, what I've called procurement responsibility. Was there negligence or recklessness in the procurement process where this latent defect should have been debugged, but it wasn't? Because I think we need to think about how do we ensure the same influence on the autonomous judgment that we try and ensure for the soldier who's exercising that what is in effect. I mean, every soldier is an autonomous weapon as well, but they're influenced by the commander. And that's why the commander is held criminally accountable when there's a foreseeable defect in that judgment.
Thank you, Jeff. Anybody else want to weigh in on that? If not, let me go to another question, a question that has come up in a number of panels having to do with Professor Moyne's now controversial piece about how, in his estimation, the progress that has been made in developing and humanizing war through the development of further restrictions in IHL, in fact, helps to prolong war and is counter-humanitarian. His arguments are much more nuanced than that. Let me also add, though, to that question, which a couple of people asked, another proposition, which is that the criminalization of law of war violations by shifting the focus to the criminal nature of violations may also tend to influence commanders and others in the field to have the boundaries of criminality guiding their conduct rather than the boundaries of what IHL requires. And for that distinction, I think it's important to recognize that there are many, many violations of IHL, principles of IHL, that are not necessarily subject to criminal responsibility for their violation, at least some in nature and some in degree. So wondering what panelists' thoughts are about progress in the realm of IHL and progress in the realm of criminalization of IHL violations that might have a counterproductive effect on the project of either prohibiting war or preventing dehumanization in war.
I mean, I'd be glad to comment to start off. My biggest objection to both of those theses is I believe it fails to recognize the true responsibility of a military commander, which is not only to ensure accomplishment of the mission, but also to protect the moral integrity of the men and women that are entrusted to the command. So the idea that the international humanitarian law has exacerbated conflict by imposing these unrealistic constraints fails to account for the corrosive moral effect of asking young men and women to engage in hostilities without rules. I mean, this goes back to James McDonough's great quote in Platoon Leader, where he says, "My job was more than just to keep them alive. It was to help them navigate the moral abyss of mortal combat." So there's a benefit of wartime constraint that extends beyond just the humanitarian protection of victims. It also extends to the warriors who have to live for a very long time with the consequences of their actions. And most people in the United States certainly have never contemplated how difficult it would be to have somebody point at another human being and say, attack that person. And then you have to live with that for the rest of your life. It's a very intimate aspect of the process. And as a father of somebody who is in the military, I worry about it more for him than I worried about it for myself. And in terms of the criminalization element, maybe Rachel can help me here, but I don't think most commanders think of their obligations to regulate the conduct of their military operations by reference to what the criminal standard might be. I think what they focus on is, what's the right thing to do under the circumstances. My job as a leader is to balance humanity against military necessity. That's something they understand and embrace. And I've got to protect not only the civilian population, not only the risk of collateral damage, but also the integrity and legitimacy of my operation. And so I'm not all that persuaded that what I think you're right about, Gabor, that the standards for criminality offer more space. For example, the ICC prohibition on proportionality violation requires a clearly excessive imbalance, but I don't think that's how military advisors are advising their commanders or our commanders are taught. Rachel?
I completely agree with you, Jeff. I mean, the outer boundaries that the criminal law sets do not provide the floor for commanders are looking at and saying, okay, this is, what can I do that's up to this? It won't let me cross the line. But separate from that, it's the fact that in reality, this just isn't happening. The criminalization is not happening. No commander is being held responsible for even dereliction of duty, because again, there is no command responsibility under military law. They're not being held responsible for their failure their failures to conduct their operations in compliance with law of war, their failures to suppress and prevent or punish. Because Lieutenant Colonel Chasani, Marine Corps, in relation to Haditha, was the only officer that the dereliction of duty charges regarding the conduct of his men were even contemplated. And because of unlawful command influence, which is a horribly corrupting influence within the military justice system, that charge went away. So at the end of the day, commanders, their war crimes accountability is and especially accountability for commanders' failures to withhold their command responsibility obligations, I think is almost non-existent, which is one of the reasons I am fully in support of vesting non-commanders with prosecutorial discretion, because maybe non-commanders will actually hold commanders responsible. I mean, maybe then we'll generate that case law that Jeff was talking about what was reasonable, what was the commander's responsibility in that particular situation.
Thank you, Rachel, and everybody else. Thank you so much. We've run out of clock. I'm sorry we didn't get to a couple of other questions. I had about 500 of them, which we also obviously won't get to. So let me just end by thanking the panelists so much. It was great to have you all. Thanking Ashika, my kind of partner in crime with the IHL committee, and thanking Arbitration Place as well for all your technical assistance. And most of all, those of you out there who have attended and participated and asked questions, thank you so much for being here as well. With that, enjoy the rest of the conference, everybody. Bye-bye.
Bye-bye.
Bye,
Thank you, Gabor.
Thanks for being here.